Stop letting your employer frame the narrative. Here's exactly how to protect your rights before you take the first step to sue your boss. Now, you never took your job with the intention of suing your boss, and you actually wanted to get along with them. But when they started not paying you overtime or not paying your wages properly or making you work through your breaks, work through your lunches, making you falsify your time cards, you knew you were getting taken advantage of. And that's why you searched for this video. So I'm an attorney in California. My name is Philip Dean, and I'm going to be going through, do you have an employment law claim or not in California? And see if you do. You can reach out to me in the comments, um, and I'll take your case at no charge to you if you qualify. I have to speak to you first, but there's no charge for you. I just have a contingency where we take a piece of the winnings. So you get started for zero cost. Go ahead and get everything filed for you. But let's go through exactly what an employment law claim looks like in California. So, um, yeah, like I said, if you're working in California, you're covered by some of the most robust labor protections in the country. However, knowing the law is one thing, knowing how to navigate a violation is another. Today, we're breaking down the realities of wage theft, overtime violations, and retaliation, and what you can actually expect if you decide to take legal action. Wage, overtime, and retaliation. In California, non-exempt employees must be paid overtime, 1.5 times the regular rate. So if your normal rate is $30, 1.5 times $30 is half of 30 is 15. So 30 plus 15 is 45. So you would be paid $45 an hour. For work over 8 hours a day or 40 hours a week, common violations involve off the clock work, misclassification as an independent contractor, or failing to pay for breaks. Retaliation. This is often where the real case is. Under Labor Code Section 98.6 and Section 1102.5, it is illegal for an employer to fire, demote, or harass you for exercising your legal rights, like complaining about unpaid wages or reporting safety violations. So if you're fired for reporting unfair labor practices, then you have a big case on your hands. That's retaliation, and those cases we can win all of the lost wages possibly, because they're retaliating against you for doing the right thing, and the law in California says that that is not allowed, and I believe your attorney's fees are covered under that law. The presumption rule. As of 2024, California law creates a legal presumption of retaliation if an adverse action, like firing, occurs within 90 days of you engaging in protected activity, like complaining to HR. So if you report to your boss that they're not paying you overtime correctly, that the law requires it, and then within 90 days they fire you, you should talk to an attorney. You don't need to be right about the underlying violation to be protected from retaliation. The California Supreme Court established this in Yanowitz v. L'Oreal USA Inc. The standard is whether you had a reasonable good faith belief that the conduct you were opposing was unlawful. So even if the violation you reported was false, but you had a reasonable good faith belief that there was a violation going on in your job to report, even if you were wrong, you could still have a case, still speak to an attorney, because they allowed that to move forward, even though the original report from the employee was actually wrong. When you file, you're looking at back pay, the money they owe you, emotional distress damage, Punitive damage, if the employer's conduct was malicious, they are purposefully trying to hurt you. Attorney's fees, statutorily mandated in many labor cases. So basically, the other party will be required to pay for your attorney at the end, and you don't have to pay anything up front typically in these cases. So these are very plaintiff friendly cases. How long does this take? Timeline and payout. Realistically, most employment cases in California take between 6 and 18 months to resolve through settlement. If you go to trial, it can easily extend to 2 to 4 years due to court backlogs and discovery procedures. As for the win, there is no average. Minor wage claims might settle for a few $1,000s. Serious retaliation claims often settle in the 50,000 to 300,000 range. And then high stakes litigation involving multiple employees or egregious management behavior can reach 7 figures. Remember, 95% of these cases settle before ever seeing a jury. Employers settle because they want to avoid the risk of a runaway jury verdict and the certainty of mounting legal fees. And remember, they're responsible for the attorney's fees. So the longer on we go, the more of those fees are racking up, and the more they'll have to pay if we go to trial and win. And so these cases often settle before trial, but they'll go on for 6 months to 2 years, as trial dates can be set out a year or two in the future. If you believe your rights have been violated, document everything. Take just handwritten notes in a journal or a Word document. But just take the notes, write your name next to the note, sign it, write the time of day when you took the note, the date. So an example, today is June 1st, 2026, and on this day, my boss told me to work through my lunch from 12 to 1 p.m. So I clocked out for that time, but worked anyways. And my boss, Jeremy Smith, told me to do this verbally on the floor, standing in front of the cash register. So paint a picture of who's involved, what happened, where did it happen, when did it happen, how did it happen, the who, what, when, where, how, and why. And yeah, write it all down and sign it with your signature if it's written, or just write your name under it and date it if you're typing it. Key resources and document everything: emails, timesheets, dates of conversations. The law is on your side, but it requires diligent evidence gathering. I'm Philip Dean. Know your rights. Yanowitz v. L'Oreal USA Inc., the seminal case defining protected activity under FICA. It establishes that an employee's opposition to an unlawful practice is protected, even if the practice did not actually violate the law, provided the employee holds a reasonable good faith belief. Applicable statutes: California Labor Code, Section 98.6, prohibits retaliation for filing a claim or complaint about unpaid wages. So oftentimes people are afraid to report cases because they're afraid their boss will retaliate against them. But if they do, they win a lot more money. So really, the thing that you're worried about from not pursuing an employment law case is the one thing that would actually help you a lot, because once they retaliate, you can get $50,000 to $300,000 depending on the scenario. So that retaliation pays deeply. So it's not something to be afraid of. In fact, it would just help your case. And in the future, when you go to get other jobs, you might be worried about, oh, well, now I'll have this reputation for having sued my employer. But as part of settlement, we can require that they don't speak about it, and you don't have to report it in your future jobs. So it's not like everyone will automatically know. They can find the case online, but most likely they won't. And if they do, if someone doesn't hire you just because you pursued your rights to sue someone for breaking the law, then you got another lawsuit on your hands possibly. So I wouldn't worry about not pursuing a case because of your reputation in the industry. or not getting rehired somewhere else, or um, those kind of reasons, because the law protects people from those discrimination and retaliation for people who are whistleblowers and reporting, you know, violations of labor law. So speak to an attorney and see if what you're worried about may not even be something to worry about, might be an advantage to just earn more money. Um, so pre-litigation demand takes 1 to 3 months. Discovery takes 8 to 16 months. Total to settlement 6 to 18 months. Total to trial 2 to 4 years. Financial outcome: minor disputes 5,000 to 25,000. Let's say employer didn't pay you, you know, for a 15-minute break for a span of 6 months. Or sorry, the employer forced you to work through your break for 15-minute break for 6 months. It could be 5 to 25K. Standard wage retaliation, 50,000 to 300,000. And complex high value, 500,000 to 1 million. That's more so with class action suits and egregious behavior. This is for educational purposes only and does not constitute formal legal advice or create an attorney-client relationship. Laws change and individual case outcomes depend entirely on specific facts and evidence. Thank you very much, guys. If you have a labor law case in California, please reach out in the comments, or find me on LinkedIn as Philip Dean, Instagram as Paralegal Phil. I'm not a paralegal anymore. I'm an attorney now, but still have the name on Instagram, Paralegal Phil, LinkedIn, Philip Dean, and Facebook, Philip Dean. And my office is the Law Office of Philip Dean. So thank you very much, guys. If you have a labor law claim, I'm sorry your boss sucks, but let's sue them together. Have a good one.